Section 2A of Indian Contract Act defines about the proposal. Proposal. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtain assent of that other to such act is said to make a proposal. उसको बोलते हैं proposal. इसमें दोनों चीज दी है, पॉजिटिव दिया है, निगेटिव दिया है. पॉजिटिव मीन्स विलिंगनेस टू डू, उसको पॉजिटिव बोलते हैं, और निगेटिव मीन्स टू एब्सटेन फ्रॉम डूइंग एनीथिंग, ये चीजें नहीं करनी है. जब एक पर्सन सिग्निफाई करता है किसको, दूसरे पर्सन को, उसका विलिंगनेस या ये चीजें नहीं करूंगा, और ये क्यों है, विद अ व्यू to obtain assent of that other to such act, he is said to make a proposal. A person who makes a proposal is called promisor. Person to whom proposal or offer is made is promising. So now we will see about essentials of a valid proposal. So 6 important points are there. First, the proposal may be expressed. Expressed means writing में हो सकता है, या by spoken words, or may be implied. Implied means by conduct of parties. Second, proposal may be to do an act, means positive, or refrain from doing any act, that is negative. Proposal may be to do an act or refrain from doing any act. Third, proposal must be made with a view to be accepted, not declaration. It must be agreed by promise. Agree होना चाहिए. And fourth, the proposal must be intended to create legal obligations. Intention होना चाहिए legal obligation बनने का. Proposal must be intended to create legal obligation. इसमें केस लॉ है, कलाई हल्दर वर्सेस शेख. Proposal must be made to define a persons or a class of persons or to the world at large. ये proposal है, defined person के लिए हो सकता है, क्लास ऑफ पर्सन्स के लिए हो सकता है, या टू द वर्ल्ड एट लार्ज. एग्जाम्पल है इसका, ए ऑफर्स टू सेल हाउस ए टू बी, दैट इज डेफिनेट पर्सन. एडवर्टाइजमेंट इन अ न्यूज़पेपर मीन्स वर्ल्ड एट लार्ज. जब आप एडवर्टाइज देते हो तो डिफाइनेट पर्सन के लिए नहीं रहता है, वर्ल्ड एट लार्ज के लिए रहता है. And last essentials of valid proposal, proposal must be communicated. So these are the important essential ingredients of valid proposal. Then और क्या क्या important points है आपके proposal के related? When the proposal is accepted as it is, it becomes acceptance of proposal. When offeree does not accept as it is, it becomes counter offer. मैंने आपको क्लियर पॉइंट किया. काउंटर ऑफर को क्या बोलते हैं, काउंटर ऑफर कब होता है, और जब प्रपोज एक्सेप्ट होता है, पर्पस टू कम्युनिकेट विद द सोसाइटी एट लार्ज टू नेगोशिएट ऑब्लिगेशन. इन्विटेशन टू ऑफर मीन्स इट इज डिफरेंट फ्रॉम ऑफर. पर्पस टू कम्युनिकेट विद द सोसाइटी एट द लार्ज to negotiate about his proposal, उसको बोलते हैं invitation to offer. ये जो invitation है does not create any legal obligation. और तीसरा important है, no final expression of willingness on the part of offerer. अभी ये example कौन से है offers के, तो अभी आप देखा जाएगा तो आप कैटलॉग देखते हो, catalog of a price of goods in the shop, then advertisement of tailors, then auction सेल रहता है वो, proposal for insurance company, and open offer, standing offer. So this all about your proposal or offer. Then second, acceptance. Section 2B of Indian Contract Act 1872. Acceptance. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. जब पर्सन जिसके लिए प्रपोजल किया है सिग्निफाई करता है उसका एसेंट प्रपोजल को, उस टाइम में प्रपोजल एक्सेप्टेड करके बोलते हैं. प्रोमिसर मीन्स द पर्सन मेकिंग द प्रपोजल. जो पर्सन प्रपोज करता है, प्रपोजल देता है, उसको प्रोमिसर बोलते हैं. प्रोमिसी मीन्स द पर्सन एक्सेप्टिंग द प्रपोजल. जो पर्सन एक्सेप्ट करता है प्रपोजल उसको प्रोमिसी बोलते हैं. देन इसेंशियल्स ऑफ वैलिड एक्सेप्टेंस. इसेंशियल्स क्या है वैलिड एक्सेप्टेंस के? तो पहला पॉइंट है, 8 पॉइंट है इसमें इंपॉर्टेंट. पहला पॉइंट है एक्सेप्टेंस मस्ट बी एक्सप्रेस्ड और इम्प्लाइड. Acceptance is said to be expressed when it is communicated orally or in writing. Acceptance express बोलते हैं. कब बोलते हैं? जब communicate होता है orally या writing में होता है. Acceptance is said to be implied when it is indicated without written document. In such case, the acceptance can be presumed when the acceptor performs the conditions of proposal. This is regarding section 8 and section 9. For example, advertisement है pharmaceutical company के. किसके लिए? For medicines use and offers forwarded in advertisement. Second, acceptance must be absolute and unconditional. Acceptance must be in terms of the proposal without any variation, addition or deletion. When there is a variation, it is counter proposal. जब उसमें वेरिएशन होता है उसको काउंटर प्रपोजल बोलते हैं. कंडीशनल एक्सेप्टेंस इज नो एक्सेप्टेंस. कंडीशनल एक्सेप्टेंस इज नो एक्सेप्टेंस. The principle behind this essential of valid acceptance is both the parties must have one mind and one sense of proposal. उसमें दोनों चीज है, one mind होना है और one sense of proposal होना है. Third essential, mental acceptance is not valid. Mental acceptance of the proposal without communication by the offeree is not acceptance at all in law. फिर से बताता हूं, जो मेंटल एक्सेप्टेंस है प्रपोजल का, लेकिन आपने उसको कम्युनिकेशन नहीं किया है, विदाउट कम्युनिकेशन बाय द ऑफरी इज नॉट एक्सेप्टेंस एट ऑल इन लॉ. इट डज नॉट कंक्लूड कॉन्ट्रैक्ट. ये कॉन्ट्रैक्ट कंक्लूड नहीं होता है इससे. एक केस हुआ इसके ऊपर, भगवान दास वर्सेस गिरदिल्ला, AIR 1966 SC 543. In this case, Supreme Court observed that an agreement does not result from a mere state of a mind as presumed by the offerer. There must be some external manifestations of that intent by speech, writing or act of the offeree to accept the offer. Then fourth, the acceptance must be expressed in some usual and a reasonable manner. ये जो acceptance है express करना है usual या reasonable manner में. Section 7 subsection 2. The proposer can prescribe the manner and time limit in which the proposal can be accepted. ये जो प्रपोजर है वो प्रिस्क्राइब कर सकता है मैनर में और टाइम लिमिट में प्रपोजल एक्सेप्ट कब तक करना है. If the manner and time is not prescribed by the proposer, then it should be accepted by the acceptor in some usual and reasonable manner and reasonable time. जब टाइम्स प्रिस्क्राइब नहीं किया है, मैनर प्रिस्क्राइब नहीं किया है, तो एक्सेप्टर को जो प्रपोजल है वो एक्सेप्ट करना रहेगा. तो ये यूजुअल, रीजनेबल मैनर और रीजनेबल टाइम में करना है. फिफ्थ, acceptance of an offer amounts to acceptance of all its terms. When the offer is clearly communicated to the offeree and accepted by the offeree, it is presumed that the offeree has accepted all the terms of the offer, although he may be ignorant of some of the terms. For example, railway, airline tickets, credit card forms, etc. So, acceptance of an offer amounts to the acceptance of all its terms. Then, mode of acceptance. Where there is no manner or a mode prescribed by the offerer, then the acceptance must be made in the by express spoken words, by express written words, by conduct or doing some act, by post or by telegram. And point number 7, acceptance must be made by a certain person. The proposal made either to a definite person or word at a large. That is, word at a large means advertisement. If it is made to a definite person, then it must be accepted by that person alone. If it is made to word at a large, then it can be accepted by the person who accepts it first. Then last point, acceptance must be communicated to offerer. In order to create binding contract, acceptance must be communicated to offerer. जिसने ऑफर किया है उसको कम्युनिकेट करना है. ये essentials में आ गए. Then next point, rules related to communication, acceptance and revocation of proposals. रूल से अभी है रिलेटेड टू कम्युनिकेशन, एक्सेप्टेंस के रिलेटेड है, रिवोकेशन के प्रपोजल के रिलेटेड है. तो इसमें 8 इंपॉर्टेंट पॉइंट है, 8 इंपॉर्टेंट पॉइंट्स आ गए. फर्स्ट, कम्युनिकेशन, acceptance and revocation of proposal are deemed to be made by any act or omission of the party proposing, accepting or revoking, by which he intends to communicate such proposal, acceptance or revocation. Section 3. Then section 13 में दिया है communication of the proposal and acceptance. The acceptance of the proposal must be communicated to the person who makes the proposal, in order that two minds may come together and agree upon the same thing in the same sense. Such communication may be made by doing any act or omission, means positive and negative. Communication of proposal when complete. The communication of the proposal is complete when it comes to the knowledge of the person to whom it is made. When a letter is received, section 4. The communication of the proposal is complete when it comes to the knowledge of the person to whom it is made. when a letter is received. That is section 4. Omission. Something that one has a moral or a legal obligation to do. Then communication of an acceptance when complete. As against a proposer, when it is put in the course of transmission to the proposer so as to be out of the power of acceptor. As against the acceptors, when it comes to the knowledge of the proposer. Then point number 5, communication of revocation when complete. The communication of revocation is complete. First point, as against a person who makes it, when it is put into the course of transmission to the person to whom it is made, so as to be out of the power of that person who makes it. As against the person whom it is made, when it comes to his knowledge. Rule number 6. When proposal may be revoked, a proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer, but not afterwards. Clearly दिया है रूल नंबर 6 में. When proposal may be revoked, proposal कब revoke हो सकता है? A proposal may be revoked at any time. कौन से भी words? When the acceptance may be revoked, acceptance कब भी revoke हो सकता है? Rule number 7. An acceptance may be revoked at any time before the communication of the acceptance is complete as against the acceptor, but not afterwards. I will repeat the same. When acceptance may be revoked, when the acceptance is revoked, the acceptance may be revoked at any time before the communication of the acceptance is complete as against the acceptor, but not afterwards. Then, point number 8. How proposal or acceptance stands revoked. Section number 6. Section 6 of Indian Contract Act. How proposal or acceptance stands revoked. तो भी इसके 5 points है, 5 points are there. First point, revocation by notice. A proposal and an acceptance can come to an end by notice of revocation served by the either parties as the case may be. So पहला mode है revocation by notice. Second, revocation by lapse of time limit. दूसरा time limit के ऊपर है. If the time limit is prescribed for acceptance of the proposal by the offerer, then it must be accepted before the time limit ends. If it is not accepted within the time limit, it automatically lapses when the time limit is over. जब टाइम लिमिट प्रिस्क्राइब किया एक्सेप्टेंस का प्रपोजल का ऑफर ने और टाइम लिमिट खत्म होने के बाद तो रिवोक हो जाता है. सो रिवोकेशन बाय लैप्स ऑफ द टाइम लिमिट. थर्ड, रिवोकेशन बाय फेलियर of fulfillment of conditions. If the acceptors has to fulfill the condition as may be prescribed by the proposer as a condition precedent to the acceptance, the proposal lapses on the failure of the fulfillment of the condition. Non-payment of earnest money or deposit. So these are the examples. अभी कंडीशन है, प्रेसिडेंट मीन्स पहले वो कंडीशन आपको फुलफिल करनी है और वो कंडीशन फुलफिल आपने किया ही नहीं तो उस टाइम में ये रिवोकेशन होता है, रिवोकेशन बाय फेल्यूर, रिवोकेशन बाय फेल्यूर और फुलफिलमेंट ऑफ द कंडीशन. Then revocation by death or insanity of the proposer. कभी हो जाता है revocation by death or insanity of the proposer. The proposal expires or is revoked on the death or by the insanity of the proposer. Death हो गया, insanity हो गई, उस टाइम में रिवोकेशन हो जाता है प्रपोजल. एंड लास्ट पॉइंट, रिवोकेशन बाय काउंटर ऑफर. अ प्रपोजल स्टैंड्स रिवोक्ड इफ द काउंटर प्रपोजल इज मेड. इट वर्क्स एज अ रिजेक्शन ऑफ द ओरिजिनल प्रपोजल. जो आपने ओरिजिनल प्रपोजल किया है वो रिवोक हो जाता है, क्योंकि आपने क्या किया है, काउंटर प्रपोजल किया है. So these are nothing but when proposals or how proposal or acceptance stands revoked. Section 6 में दिया है, पहले revocation by notice, second revocation by lapse of the time, revocation by failure of fulfillment of condition, revocation by death or insanity of the proposer, and revocation by counter offer. Then valid agreements or a contract. What agreements are contract? An agreement which is enforceable by law is a contract. Offer plus acceptance is equal to agreement. Agreement plus enforceability by law is a contract. Under these sections, all agreements are contracts if they are made between the competent parties with their free consent for a lawful consideration and object. They are not expressly declared to be void under that, and contract must be in writing. Then consent. Definition of consent. Two or more persons are said to consent when they agree upon the same thing in the same sense. The two important चीजें, same thing in the same sense. The two or more persons are said to consent. दो या दो से ज़्यादा पर्सन है, कंसेंट पे है, कभी बोलेंगे when they agree, वो agree करते हैं क्या, upon the same thing in the same sense. When two persons desire to enter into an agreement, they must understand the same thing in the same sense. There must be a concurrence of a mind, or there must be a consent of both the parties. Concurrence होना चाहिए माइंड का, या consent होना चाहिए दोनों parties का. For the validity of the contract, not only consent but a pre-consent is necessary. ये जो आपका वैलिडिटी है कॉन्ट्रैक्ट के लिए, वैलिड रहेगा कॉन्ट्रैक्ट कब, सिर्फ कंसेंट ही नहीं जरूरी, प्री कंसेंट इज नेसेसरी. अभी जो कंसेंट है मराठी में उसको सहमति बोलते हैं. कंसेंट इज सेड टू बी फ्री when it is not caused by, so 5 points are there. First, coercion, second, undue influence, third, fraud, fourth, misrepresentation, and fifth, mistake. So these are nothing but 5 clauses. Consent is said to be free when it is not caused by. जब consent है, free consent रहती है, जब उसमें coercion means धमकाना, undue influence नहीं होना है, fraud नहीं होना है, misrepresentation नहीं होना है, mistake नहीं होना है. Coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code or the unlawful detaining or threatening to detain any property to the prejudice of any person, whatever, with the intention of causing any person to enter into an agreement. So ये जो coercion है उसके essentials कितने हैं? 4 important essentials है coercion के. पहला है committing or threatening to commit any act which is forbidden by the IPC, Indian Penal Code. Commit करना या threaten करना, commit का. Any act, कोई भी ऐसा जो act है which is forbidden by IPC, Indian Penal Code है, उसमें पता ये चीजें नहीं करनी है और वो चीजें करना या धमकाना वो चीजें करने के लिए रिलेटेड, ये पहला इंग्रेडिएंट आ गया. सेकेंड, इट मे प्रोसीड फ्रॉम एनी पर्सन. थर्ड, it may be directed against any person. And fourth, it is immaterial whether IPC was in force or not at a place where coercion is employed. So these are nothing but 4 essentials of coercion. इफेक्ट क्या है ये coercion का? धमकाया तो धमकाए का इफेक्ट क्या आ जाएगा? When the consent to an agreement is obtained by coercion, the agreement is voidable at the option of the party whose consent was so obtained. जब कंसेंट लिया है और वो भी कैसे किया? कोर्जन से किया, धमकाने से किया है, तो ये जो एग्रीमेंट बना है वो वॉइडेबल है. कि किसके ऊपर है? एट द ऑप्शन ऑफ द पार्टीज हुज कंसेंट वाज सो ऑब्टेन्ड. इसका सहमति लिया, उसको बोलना पड़ेगा मेरे को धमकाया था, मेरी फ्री कंसेंट नहीं थी, कंसेंट जेन्युइन नहीं था, मेरे को धमकाया था और मेरी सिग्नेचर लिया था, मेरा कंसेंट लिया था. सेकेंड पॉइंट, अ पर्सन टू whom any money has been paid or anything delivered under coercion must repay it. जब कोई पर्सन को कोई मनी दिया रहेगा धमका के या एनीथिंग डिलीवर्ड अंडर कोर्जन, उसको फिर से वो देना पड़ता है. Then second point, undue influence. A contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the party is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. Dominate करना चाहिए एक पर्सन दूसरे पर्सन को और unfair advantage लेना चाहिए. अब ये essentials क्या है undue influence के? तो 3 essentials है undue influence के. First, one party to the contract must be in a position to dominate the will of the other party to the contract. Second, the party who is in a dominant position must use that dominant position to obtain unfair advantages over the other party. And third, the unfair advantage, that is any benefit, gain or means, must come into existence from the use of the dominant position of the party to the contract. ये अभी इफेक्ट क्या है? undue influence हो गया तो इसका इफेक्ट क्या है? When the consent to an agreement is caused by undue influence, the agreement is a contract voidable. Is a contract voidable at the option of the parties whose consent was so obtained. Any such contract may be set aside either absolutely or upon such terms and conditions as the court may deem just. उसके बाद है fraud, section 17. Fraud means and included any of the following acts committed by a party to a contract with his connivance or by his agent with intent to deceive another party thereto or his agent or to induce him to enter into the contract. The suggestions as to the fact that one knows it is not true. Second, any such acts as the law declares to be fraudulent. So ये fraud है उसके ingredients क्या है? There must be intention to deceive. Second, the act of a fraud must be done by a party to a contract. Third, there must be an active concealment of a fact. Fact को छुपाना चाहिए. Or false promise must be made. And fifth, the other party to the contract must have acted upon such false statement. अभी इसमें एक important point है, non-disclosure of the facts as to those facts does not amount to fraud when a person is not under any obligation to disclose those facts. अब ये जो fraud है उसका इफेक्ट क्या होता है? इफेक्ट ऑफ फ्रॉड, सो तीन इंपॉर्टेंट चीजें. पहला पॉइंट है, इसमें क्या होता है? द पर्सन हु इज इंड्यूस्ड टू एंटर इनटू एन एग्रीमेंट बाय फ्रॉड, उसके पास तीन रेमेडीज है. पहला रेमेडी है, he may cancel the contract and file a suit for damages suffered by him. पहले कैंसिल करेगा या सूट फाइल करेगा डैमेजेस के लिए, उसको जितना डैमेज हुआ है वो सफर हुआ है वो मांगने के लिए सूट फाइल करेगा. सेकंड, he may insist that the contract shall be performed and he shall be put in the same position in which he would have been if the representation made had been true. And third, if such consent was obtained by fraudulent within the meaning of section 17 of the Indian Contract Act is not voidable if the parties whose consent was so caused had means of discovering the truth. So these are nothing but the effect of frauds. Then misrepresentation. So misrepresentation means making a false statement relating to the subject matter of a contract, but it does not include any intention to deceive the other person. It means a person who makes a false statement, believing it to be true and not knowing it to be false, without intention, without any intention to deceive. So ingredient तीन है इसके misrepresentations के. पहला है unwarranted positive assertion. Second, breach of a duty, means non-disclosure of a title of the property. And third, inducing a party to a contract to make a mistake. It is essential that one party should make a mistake in pursuance to the misstatement of the other. What are the effects of the misrepresentation? तो तीन है इसके effects. The person who is induced to enter into an agreement by misrepresentation, तो उसके पास तीन रेमेडीज अवेलेबल है. पहला, he may avoid the contract and file a suit for damages if any suffered by him. Second, he may insist that the contract shall be performed and he shall be put in the position in which he would have been if the representation made had been true. Third, if such consent is caused by misrepresentation, the contract is not voidable if the party whose consent was so caused had means of discovering the truth with ordinary diligence. That is it first. Then fifth point, mistake. Mistake is one of the important element by which a contract becomes voidable. Mistake is important element है. Contracts voidable हो सकता है. Mistake invalidates the consent to an agreement or it may mislead the parties to the contract. अभी इसके भी दो प्रकार है, mistake of fact and mistake on the part of both the parties to the agreement. पहला point है mistake of fact. Mistake of fact consists in an ignorance, misapprehension, or misunderstanding of the truth or incorrect belief as to the existence of the fact material to the transaction. And second point, mistake on the part of both the parties to an agreement. Where both the parties to an agreement are under mistake as to a matter of fact, essentials to the agreement is void. So, what are the essentials of mistakes? Mistake के essentials क्या है? तो पहला है the mistake must be mistake of fact and not mistake of law. पहला ingredient क्या है? Mistake of fact होना चाहिए, mistake of law का नहीं होना चाहिए. Second, mistake as to the subject matter. That is, contract is void. Mistake as to the nature of contract. इसमें भी nature है तो contract is void. Fourth, mistake on the part of one of the parties to an agreement, a contract is not voidable. And fifth one, mistake of law, a contract is not voidable. So these are nothing but the essentials of mistakes. Then next important chapter, consideration. Consideration important chapter है consideration. Section 2D of Indian Contract Act defines consideration. When at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstain from doing or promises or abstain from doing something, such act or promise is called consideration for the promise. उसको consideration बोलते हैं promise का. Section 2D में Indian Contract Act 1872 में consideration का definition दिया है. कितना simple दिया है देखो. When at the desire of the promisor. किसकी desire है? Promisor की desire है. The promisee और any other person, एक तो promisee रहेगा या कोई दूसरा कोई बंदा रहेगा, has done कुछ इसकी है, और abstain from doing, or does or abstain from doing, or promises or abstain from doing something, such act or promise is called consideration of the promise. अभी इसकी essential elements दो है. पहला है consideration must be given at the desire of the promisor. Promisor के desire के ऊपर होता है. Consideration must be given at the desire of the promisor. Second, consideration may be given by the promise or any other person under Indian law. The consideration may proceed from the promisee or any other person. Therefore, a stranger to the consideration can sue on a contract. A general rule is that a person who is not a party to a contract cannot sue upon it. But there are certain exceptions to this rule. So ये जो general rule है, क्या general rule है? A person who is not a party to a contract cannot sue upon it. उसके लिए exceptions क्या है? तो 5 exceptions है. There are 5 exceptions to this general law, general rule. First, a beneficiary of the trust. When a charge or other interest in some immovable property is created in favor of a person, such person may enforce it even though he is not a party to the contract. So पहला point, first point, a beneficiary of the trust. ये exception आ गया. Second, marriage, settlement, partition or other family arrangements. ये भी exception में आ गए. A stranger to a contract can sue upon it where the money is due to him under marriage, settlement, partition, or other family arrangement, and a provision is made for the benefit of him who is not a party to the arrangement, such person can enforce the arrangement even though he is not a party to such agreement. So this is another exception. Third, assignment of a contract. The assignee, in the event of a death or insolvency of the principal, can enforce the contract. उस टाइम वो कॉन्ट्रैक्ट इन्फोर्स कर सकता है, ये एक्सेप्शन है. फोर्थ, कॉन्ट्रैक्ट मेड बाय द एजेंट. When the contract is made by the agent on behalf of the principal, within the scope of his authority, the principal can enforce the contract. Then, consideration may be past, present, or future. Has done or abstained from doing something refers to past consideration. Does or abstain from doing something refers to the present consideration. Promises to do or abstain from doing refers to the future consideration. तीनों पॉइंट मैंने क्लियर कर दी. कंसिडरेशन पास्ट भी हो सकता है, कंसिडरेशन प्रेजेंट भी हो सकता है, कंसिडरेशन फ्यूचर में भी हो सकता है. तो पास्ट में कब होएगा? हैज डन और abstain from doing something. ये रिफर क्या होता है? Past consideration. Does or abstain from doing something. ये रिफर क्या होता है? Present consideration रिफर होता है. और promises to do और abstain from doing ये होता है, रिफर होता है future consideration के related. Consideration must have some value in the eyes of law. Consideration should not be unreal. It need not be adequate, but at the same time, it must also be reasonable. An agreement to which the consent of the promisor is freely given is not void merely because the consideration is inadequate. But inadequacy of the consideration may be taken into account by the court in determining the question whether the consent of the promisor was freely given. And last point, consideration must not be unlawful, immoral, or opposed to the public policy. The consideration object of agreement is lawful unless it is forbidden by law. Second, it should not defeat the provision of any law. Third, it is fraudulent. Fourth, it involves injury to the person or property of another. And fifth one, the court regards it as immoral or opposed to the public policy. So, consideration must not be unlawful, immoral, or opposed to the public policy. So these are nothing but exceptions to the general rule. A person who is not a party to a contract cannot sue upon it. So these are the exceptions. These are 5 exceptions to this general rule. Then void agreements. इसमें 7 points है. पहला point है agreement void if consideration and objects are unlawful in part. If any part of a single consideration, कोई part रहेगा single consideration करेगा for one or more objects or any one or any part of any one of the several consideration for a single object is unlawful, the agreement is void. Second, an agreement made without consideration is void unless it is in writing and registered. अभी इसमें 2 important points है. पहला है give deed on account of a natural love and affection, and second, compliance of a promise to compensate to any person who has done something for promisor. Third, agreement in restraint of a marriage, section 26. Every agreement in restraint of a marriage of any person other than minor is void. कोई आपसे एग्रीमेंट करेगा, बोलेगा शादी मत कर, तो ऐसा जो एग्रीमेंट है वो void है, और ये सेक्शन 26 of Indian Contract Act. Agreement in restraint of a trade. Every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is void. अभी इसके exceptions भी है. So 4 exceptions है इसके. पहला है the seller of the goodwill is restrained from carrying on a similar business. ये goodwill matter रहेगा तो उस टाइम में similar business वो नहीं कर सकता है. Second, the seller of the goodwill is restrained from carrying on that business only within certain local limit. Third, only for a period so long as the buyer of the goodwill is carrying on that the business. And fourth one, the restraint imposed on a business must appear to the court to be reasonable. 10. Agreement in restraint of a legal proceedings. ऐसा कोई एग्रीमेंट किया रहेगा कि void है, लीगल प्रोसीडिंग नहीं करेगा, ऐसा कोई कॉन्ट्रैक्ट किया रहेगा, एग्रीमेंट किया रहेगा, वो एग्रीमेंट इज अ void. Agreement in restraint of a legal proceedings. Then agreement void for uncertainty. Agreement, the meaning of which is not certain or capable of being made certain, are void. कोई uncertainty रहेगी एग्रीमेंट में, उसका जो मीनिंग है वो क्लियर नहीं आता है, सर्टन नहीं है, तो उस टाइम में जो एग्रीमेंट्स है वो void है. And wagering agreements. Wagering agreement means an agreement to pay a money or money's worth on the happening or non-happening of an uncertain future event, or on determination of the result of uncertain future event. Agreement by way of a wager are void. लेकिन इसके लिए भी एक्सेप्शंस है. एक्सेप्शंस फॉर wagering agreements. Games involving the skills and techniques, ये एक्सेप्शंस है. सेकेंड, exchanging of a shares. Third, prize of ₹500 or upward to be awarded to the winner of any horse race is not a wagering. Insurance contract. Then stock market में crosswords or similar competition. So these are nothing but exceptions to the wagering agreements. Then आपको question में भी put up like that, the important point is a contingent contract or a conditional contracts. Contingent or conditional contract. A conditional contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. अभी सेक्शन 33 में प्रोविजन क्या किया है? इन्फोर्समेंट ऑफ एन कंडीशनल कॉन्ट्रैक्ट. इन्फोर्स कैसे करते हैं कंडीशनल कॉन्ट्रैक्ट? सेक्शन 33 ऑफ इंडियन कॉन्ट्रैक्ट एक्ट 1872 में इसका प्रोविजन किया. So 4 important points are there. First, conditional contract to do or not to do anything if an uncertain event happens cannot be imposed by law unless and until that event has happened. If the event becomes impossible, such contract becomes void. कुछ इवेंट है वो इम्पॉसिबल रही तो उस टाइम में जो कॉन्ट्रैक्ट है वो void हो जाता है. सेक्शन 34 बोलता है कंडीशनल कॉन्ट्रैक्ट टू डू और नॉट टू डू एनीथिंग. कंडीशनल कॉन्ट्रैक्ट टू डू और नॉट टू डू एनीथिंग. सेक्शन 34 If an uncertain future event does not happen, can be imposed when the happening of the event becomes impossible and not before. अभी आपको नोट करना पड़ेगा conditional contract that becomes impossible by the conduct of the person, that is party to a contract. The third important point, section 35, conditional contract on specified event not happening within the fixed time. Fixed time में नहीं होता है. उस टाइम में क्या करेंगे? Conditional contract on specified event not happening within a fixed time. Section 35. उसमें दो points है. First point, conditional contract to do or not to do anything. If a specified uncertain event happens within a fixed time, becomes void. If at the expiration of the fixed time, such event has not happened, or if before the time fixed, such event becomes impossible. Second, conditional contract to do or not to do anything if a specified uncertain event does not happen within a fixed time may be imposed by a law when the time fixed has expired and such event has not happened or before such event will not happen. And last point, agreements contingent on impossible events are void. So this is regarding enforcement of unconditional contracts. Then last, we will conclude our lecture till today.